My name is Kristen Wilson, and this presentation is for Liberty University Online Business Course 343. We'll be discussing Grievance Case 9. Next slide. We will be looking at this case from the role of an arbitrator. It can be found on page 343 of the Text Labor Relations by John Bunn. Next slide. During this presentation, we will discuss the role of an arbitrator, the case, the testimony, relevant contract provisions, the ruling, the logic behind the ruling, our plan of action, and we'll end with a conclusion and references. Next slide. In order to better understand the decision-making process in this case, we will first look at the basic role of an arbitrator when used in grievance arbitration. Arbitrators are a neutral third party who have been requested to settle a dispute when an agreement cannot be reached by the disputing parties. Arbitrators can be used for labor contracts, international business transactions, divorce and child custody, security regulations, and general commerce. For this case, we'll be focusing on the use of arbitrators in labor contracts. If this grievance has made it to arbitration, that means that during the first three steps of the grievance procedure have failed, an arbitrator's decision will most likely be binding. An arbitrator's task in grievance arbitration is to interpret the labor contract and apply it to the situation at hand. After hearing testimony, the arbitrator will rule on the case. Generally, the employer and the union are legally bound to adhere to the arbitrator's final decision if the final step of the union's contract grievance procedures is binding arbitration. Next slide. The case. Ray Davies worked for a plant manufacturing company that produces aluminum shapes. Davies was hired on July 30th, 1990, and Christine Hines was hired on September 15th, 1990. Hines is a racker, which is considered a higher grade than Davies' current position of saw helper. Davies has officially worked for the company in numerous positions, including the packer helper, saw helper, head sawyer, which is considered the same grade as a racker, fork truck operator, and die cleaner for the firm. Next slide. Ray Davies was laid off from his position at the plant for economic reasons. Davies filed a grievance stating the plant violated the collective bargaining agreement by laying him off and retaining Hines, who was hired after him. He and his fellow union members are currently represented by the Local 491 of the International Chemical Workers Union. Since arbitration hearing was called, one can assume that a mutually satisfactory resolution was not reached by the earlier means of the grievance procedures. As an arbitrator, I reviewed the notes in the case prior to the hearing to better my understanding of the situation prior to hearing testimony. Davies' layoff prompted Local 419 to file a grievance on behalf of Davies, as they felt he should not have been laid off either. Next slide. The testimony. During the grievance hearing, Davies testified that he had the ability to become a racker. He stated he learned how to become a racker during his time as a forklift operator by filling in for a racker 15 to 20 minutes at a time and watching the other rackers. He stated he felt confident he could have satisfactorily performed the duties of a racker if he had been paired with a regular racker. The plant manager also testified at the hearing and brought up 4 different points. He stated if retained as a racker, Davies would have in fact been paired with regular racker. Secondly, Davies was a good worker and would have been able to perform well after training. Third, Davies would have had the ability of an efficient racker after 30 days of training. And lastly, 4 other men were moved into racking during the time of the company's reorganization, and one of them had the same basic filling-in training that Davies had possessed as well. As an arbitrator during this testimony, I would have been listening for the 5 W's to help better understand my decision. Next slide. The relevant legal and contractual provisions in this case are few. The plant's union contract contains the following provisions in terms of layoffs. Section 1, seniority will be on a plant-wide basis. Section 2, in all matters of promotions, demotions, transfers, jobs training, shift preference, layoff, and recall, the following would be the determining factors. A, seniority, and B, the ability to do the work required. The National Labor Relations Act also applies to this case as well. The NLRA requires that collective bargaining that led to the above provisions being agreed on by both sides. The company had a role in making these choices as well. In addition, Title 29 of the United States Code makes the union contracts enforceable. Next slide. As an arbitrator, considering primarily the legal and contractual provisions, and additionally the testimony provided by both Davies and the plant manager, I would have ruled in favor of the grievant, Ray Davies, finding that the contract provisions were indeed violated by the firm. Next slide. The contract provision states seniorities on a plant-wide basis. Seniority is also known as tenure, which is recognized as the amount of time an individual has spent with the company regardless of the position that they held. Ray Davies was in fact hired 45 days before Hines. This means Davies met the first requirement for seniority as stated by the provision. Additionally, the plant manager agreed with Davies, stating that he could have in fact performed the duties of a wrecker. This means that Davies met the second requirement in accordance with the provisions as outlined in their contract. The plant has already training 4 other men who were moved into racking during the time of the company's reorganizations, as Davies should have been at the time of the layoffs as well. Next slide. The plan of action will primarily consist of a grievance settlement that will be awarded to Davies. This settlement will include the following. The plant will pay Davies for all wages lost during missed work since the time of his layoff. The plant will also pay Davies a lump sum of $10,000 one time for any fees, fines, or credits that he incurred during his time of the layoff because of the layoff. Davies will be reinserted at the plant at either his latest position of saw helper or begin training as a racker. It was agreed upon during the hearing that Davies could do the work of a racker, but if the plant finds they are unable to begin his training immediately, Davies will be placed in his latest position as saw helper until the first available position as racker comes available, at which time Davies will be moved into that position. It will be the plant's decision whether to retain or lay off another worker in place when Davies returns. Next slide. As Davies returns to work, he and his supervisor's actions will need to be monitored. Studies have shown that employees that have filed grievances may later be treated unfairly by management. This can include rating them poorly on evaluations, giving them less desirable shifts or work assignments. While there is currently no reason to think that this will be the case for Davies and his supervisors, it is important for the union and for Davies and his superiors within the company to monitor the situation to ensure Davies is treated fairly. Davies will need to be successful in his racker training period in order to fulfill the Section 2 stating he must have the ability to perform the job required in order to avoid a layoff. Davies' reinstatement with the company is not only based on his seniority, but his ability to perform within the racker position. While the plant did violate their contractual agreement, Local 419's contract helped Davies return to his job. This grievance case was won based on the union's contract. It shows how important it is for employees to prepare accordingly for collective bargaining, and after it is completed, ensure they understand the finished contract. Had the company had a better understanding of their contractual obligations, this grievance case may have never been filed. Thank you, and next slide for reference.